Good afternoon, and will the Government Relations, Ethics, and Transparency Committee meeting of March 18th, 2025 please come to order. It is 1:34 p.m. I'm your chair, Nohelani Uuhajins. Members, in accordance with the Sunshine Law, please identify by name who, if anyone, is in the room, vehicle, workspace with you today. Minors do not need to be identified. Let's begin with Committee Vice Chair Tamara Paulton. Good afternoon.
Ya'ate, Chair,
Ya'ate.
and aloha awinala kakou.
Ya'ate. Councilmember Tom Cook, Ya'ate, and good afternoon.
Ya'ate and aloha and afternoon.
Aloha. Councilmember Gabe Johnson, Ya'ate, and good afternoon.
Ya'ate, Chair, council members, committee members, there's no testifiers at the Lanai District Office. I'm alone in my workspace and here and ready to work. Mahalo, Chair.
Thank you very much. Councilmember Tasha Kama, good afternoon, and Ya'ate.
Aloha kakahiaka, Chair, and Yatahe.
I wish it was still morning, but yeah, aloha. Aloha winala.
Oh, that's right. I'm so sorry.
That's okay.
Thank you.
We can redo the morning. Give us time again.
Yes, aloha oinala.
Aloha winala. Good afternoon, and Ya'ate, Council Chair Alice Lee.
Ya'ate, and that, of course, is from the Navajo Nation. And the Navajo Indians live in the United States, New Mexico, Arizona, and Utah.
Thank you. Councilmember Rollins Fernandez, good afternoon. Ya'ate.
Aloha awinala kako. I'm Molokai Noyahina. I'm at the Molokai District Office. Alone on my side of the office. There are currently no testifiers here. And sorry, I'm on my phone right now, just waiting for my internet to connect on my laptop.
Okay. Okay, thanks for letting us know. Let us know if you have any issues especially when we move over into executive session later. Thank you for that. Councilmember Shane Sinensi, good afternoon, and Ya'ate.
Aloha Winala, Chair, and Ya'ate. I'm here at my home office. I'm here by myself, and there are no testifiers at the Hana District Office, Chair.
Thank you. Councilmember Yukile Sugimura, good afternoon, and Ya'ate.
Good afternoon, Ya'ate, and looking forward to a productive meeting.
Same. From Corporation Counsel, we have Cody Minutodani, Deputy Corporation Counsel. Caleb Rowe will be here for the first item. Then we have Mr. Glenn Pasquale, Deputy Corporation Counsel, will be here for the second item. And John Gores, Deputy Corporation Counsel, will be here for our third item. We also have with us Moana Ludi, County Clerk, Rochelle Thompson, Deputy County Clerk, and Brad Ventura, Fire Chief. Our committee staff include Maria Leon, Committee Secretary, Casey Apo Takayama, Senior Legislative Analyst, Clarissa McDonald, Legislative Analyst, Peter Hanano, Legislative Attorney. Rochelle Kawasaki will be here later, Deputy Director of Council Services, and Jean Pokipala, Council Services Assistant Clerk. Please see the last page of the agenda for information on meeting connectivity. Testimony. Testifiers wanting to provide testimony should sign up in the lobby, join on the online meeting via Teams link, or call into the phone number noted on today's agenda. Written testimony is encouraged and can be submitted via e-comment link at mauicounty.us/agendas as well. Under the Sunshine Law, the chair will receive oral testimony for agenda items at the beginning of the meeting and as the item is called up. For individuals wishing to testify via Teams, please raise your hand by clicking on the Raise Your Hand button. If calling in, please follow the prompts via phone, *5 to raise and lower your hand, *6 to mute and unmute. Staff will add names to the testifier list in the order the testifiers sign up or raise their hands. For those on Teams, staff will lower your hand once your name is added. Staff will then call the name you're logged in under or the last 4 digits of your phone number when it is your turn to testify. At that time, staff will also enable your microphone and video. If you wish to testify anonymously, please notify staff. Otherwise, please state your name for the record at the beginning of your testimony. Oral testimony is limited to 3 minutes per item, and if you are still testifying beyond that time, I will kindly ask you to complete your testimony. Once you are done testifying or you do not wish to testify, you can also view the meeting on Akaku, Channel 53, Facebook Live, or mauicounty.us/agendas. We will do our best to take up each person in an orderly fashion, and we will now call on testifiers wishing to testify at the beginning of the meeting. Staff, if you could please call our first testifier.
Yes, Chair. Nobody signed up to testify, but it looks like somebody is approaching the podium.
Thinking about this very, very strongly.
Do we have anybody else wishing to testify?
No, Chair. Would you like me to do a last call?
Please.
If somebody would like to testify in the chamber, please let staff know, or on Microsoft Teams, please raise your hand. This is final call. 3, 2, 1. Chair, it appears that nobody wishes to testify at the beginning of the meeting.
Thank you. We will move on to Bill 3. We have before us Bill 3, 2024, entitled A Bill for an Ordinance Amending Section 2.56.060 Maui County Code related to financial disclosure statements. Bill's 3 purpose is to, 1, implement Section 10-3 of the Charter of the County of Maui, 1983, as amended, approved by the electorate at the 2022 general election, and update the procedure for filing of financial disclosure statements, and 2, increase security for county election officials. At this time, I'm going to please ask for opening comments from County Clerk Moana Ludi and Deputy County Clerk Rochelle Thompson.
Thank you, Madam Chair. I'll keep this brief. Our main purpose is to obviously update the county code with the changes that were approved by the voters to Section 10.3 of the Charter back in the 2022 general election. In addition to that, we're requesting that the council approve, including a provision that the clerk and deputy clerk's financial disclosure statements are among those types of FDS that are confidential. And the reason that we're asking is you've all read in the newspapers about some of the incidents and attacks on election officials nationwide. And while thankfully we have not experienced physical violence, I think the election season has just drawn out people's heightened emotions. And so we would prefer that people who may be disgruntled with the election process or with us personally don't come to visit us at home, basically. And some of the information in the financial disclosure statements does involve our personal residence and things like that that could be used to track us down in our private lives. So that is the reason for the inclusion of that provision under number 3. It's 2.56.060. Number 3 is what I'm talking about. Thank you very much for your consideration.
Thank you. Do we have Mr. Rowe online with us? Okay. Does he? Oh, he's online. Yeah. Thank you. We just want to know, hi, if you have any opening comments.
My opening comment is similar to what Rochelle just stated. The main purpose of this is to make the Maui County Code consistent with what the charter says. The language that's currently under that section for the deadlines for filing an FDS are inconsistent with the new charter language. The Board of Ethics has been following the charter language as to when things are due, but we just think that it's a good idea to have them be consistent with one another.
Thank you. Before we get into the discussion, let's receive testimony for this item. If we have any testifiers, please.
Chair, there's currently no one who has signed up to testify. If somebody would like to testify in the chamber, please let staff know, or on Microsoft Teams, please raise your hand. This is final call. 3, 2, 1. Chair, it appears that nobody wishes to testify.
Thank you. Members, seeing there are no individuals wishing to testify on this item without objection, I would now close the oral testimony.
No objections.
Thank you. And as a reminder, written testimony will continue to be accepted. We're going to be implementing a 3-minute questioning period with a follow-up round if needed. So if you have any questions, I'm not going to go down a line. Please just raise your hand. Member Paulton.
Thank you. I'm working off the correspondence from Corporation Council version. And I had 3 questions. The first question is the part where it says the disclosure must be filed prior to taking office or a reso appointing approving the appointment, which I guess the prior to taking office one would be like for deputies maybe. But just because it's filed with the Board of Ethics doesn't mean that they have reviewed it. And so then what happens if they review it and they have taken issue? That's the first question. The second question, sworn under oath, is that just you sign it? It doesn't need to be notarized? And then the third question is, it looks like the public disclosure section has been taken out in its entirety. And if I'm mistaken, if you could point me to where it is.
You want Deputy Corporation Counsel Rowe to answer your questions, Member Paulton?
Whoever is capable.
Okay.
Okay, so I can kind of go through those one at a time. So as to when they're received, so the way that it currently works is you are required to file it if you're an appointed officer or if you are a member of a board or commission. We require that it be submitted prior to the date of the resolution approving of your appointment. If you do that, then you can participate in the next meeting, for example, if you're a member of a board and commission. And if you don't, then you have to wait until the board has reviewed it. So the board does, when it's filed, it means that it's been sent to the board, it's been filed with them. Then the board reviews it and acknowledges it as received. Or if they have questions, they send it back for clarification. And potentially, if there are concerns, they could either launch an investigation or they could initiate a complaint process. So that's kind of what the process is for it.
So they would be serving before the Board of Ethics gets a chance to review it. And if they have concerns, they either launch a complaint or call somebody in for questions. But do they have the ability, if they have strong enough concerns, to say, oh, wait a minute, I don't think you should be on this board?
So the board does not currently have the power to reject a council selected appointee, basically. If, we get it when the council has kind of already made their determination of that we don't have the opportunity to cancel. We do have, the board does have the power to impeach officers. So that's one of the things that they have. They can also send it to the appointing authority, raising the concerns with the appointing authority, who can then institute kind of its own method. So if it were someone from a board and commission, we could send it either to the department that sponsors the board or commission, or we could send it to the council mentioning the concerns.
I guess
but
from my perspective, that's kind of messy. Like, I wouldn't want to have someone on the board and then we might have to impeach them, or we send our concerns to the appointing authority. Like, to me, I would almost amend it to say reviewed by the Board of Ethics prior to taking office, or a resol approving their appointment, so that all of that is settled before that happens.
That's a well taken point. Just one thing that I will raise is that a problem that we had, less so this year because we did have more members of the Board of Ethics, is we were having trouble getting quorum. So there were a lot of boards and commissions that had pending applicants that we weren't able to review, and so they weren't able to participate in there. So it was causing a backlog in a lot of things. I think that the current system kind of addresses that. You can kind of start participating as long as you submit it in time, but the board still has an opportunity to review it and take action if they feel it's necessary. So the issues, I understand the issue that you mentioned, but there was kind of there were problems based on us having quorum and it affecting other boards and commissions doing business.
Okay, I heard my bell.
Thank you, Member Paulton. Members, does anybody else have any questions? Okay. Member Sugimura.
I see the value in this. But with all the trouble that we've been having with the INB board and how confusing it has gotten, this and that, and the mayor this, and INB that, and this just adds another layer of hope we can make it happen. That's all I want to say. But I support it.
Thank you. Any other questions? We have county clerks here as well as Deputy Corporation Counsel. Member Paulton, do you have any more questions? Feel free to ask.
Sure. I didn't get an answer to the second and third question. Does sworn under oath just mean you affirm and you sign it, or does it need to get notarized? And then public disclosure, if that's in another section, I guess related to that would it be okay with the county clerk situation if we just redacted any personal information? Like when we get the applications from board and commission, there's personal information of how to contact them and their address, and that part is not posted. Is that an option also?
So I can answer, I can attempt to answer both of those questions. So that is correct that it only requires a signature. It doesn't require, there's not a notarization requirement. You guys, for example, you guys file hard copies of your financial disclosures, but most of the other officers and employees do it electronically. And so that, you know, that just involves a simple signature and not a, not any sort of notarization. Regarding you had asked a question about public inspection on here, I believe. Could you remind me of what that question was? I kind of got lost a little bit answering the other one.
At the bottom of the third page of the bill, there's a section D, filing requirements, all public financial disclosures. So that has been bracketed out. Is that, I didn't see it tucked in any other place. And so what is the information of public financial disclosure? How do people know that it's required to be available for inspection and that the confidential ones aren't? Like, why did we reveal that section?
So that was actually my recommendation, just because I thought that was redundant, but it was redundant but I don't feel real strongly about it. So if you look up earlier under section A, it says all candidates to elective office must file a public financial disclosure statement. So it says there that it's public. It states that officers with significant discretionary powers must file a public financial disclosure statement. And then under boards and commissions, it says that they must file a confidential financial disclosure statement. So the only reason that I took that out is because I thought it was redundant to specify that candidates and employees and officers designated were public and that boards and commissions were confidential in the section specifically referring to them, and then also saying, these are public and these are confidential. But I don't feel strongly about that. I just thought it was repetitive.
Yeah, I see the repetitive part. I guess the one part that isn't repeated is and shall be public records available for inspection, which I guess could be inferred, but we've had a case before where, like, as of the deadline of the filing deadline, the financial disclosure wasn't available for public inspection, but it was on the confidential side. I don't know if you remember that situation, and that candidate got disqualified. So just saying it's a public record and then leaving out that available and shall be public records available for inspection, I feel that part should be in there so that, if somebody can't find the public record, they can point to it like, hey, it says right here that it shall be available for public inspection. And I think that's more clear for your average person, that they have a right to see it.
So,
Oh, okay, hold on. Is your
Your mic.
mic on?
I noticed the same thing you noticed, Member Vice Chair Paulton. And when Caleb and I were preparing for this hearing, I asked him the exact same question, number 3. And he gave me the same answer that he just gave you too. So I think you're correct in saying that it requires sort of an inference with regard to inspection. So that, I asked him the same thing.
Yeah, I think for me, I would like to keep in shall be, I don't care where it is, but and shall be public records available for inspection, because not everyone makes that jump that they're entitled to inspect it.
And I think Mr. Rose said he didn't feel that strongly about it too. So I'll leave that up to him to decide or see what he's going to say.
Thank you. Member Rollins Fernandez, did you have a question?
Yes, mahalo, Chair. Aloha, everyone. So I was looking at all the, financial disclosure statements, and mine in particular, and to see where the address, since that was one of the concerns, on Molokai, our mailing addresses are all PO boxes. So like for me, I don't have that same concern that was shared earlier. But I am supportive of having that section redacted. I do submit my financial disclosure online, and I'm sure that whoever does our software, our IT folks or whatever, can have that section like blacked out or, whatever. But the rest of the information, I don't think is, I think it's important to have public. So in looking at Bill 3, the section, subsection D that Member Paulton is talking about, filing requirements, all public financial disclosure statements, etc. If part of the concern that Mr. Rowe is talking about is that the public financial disclosure statement and all confidential financial disclosure statements is redundant, I would be supportive of deleting the last sentence and then we just leave in the first sentence. Would that make a difference, Mr. Rowe?
I don't feel real strongly either way about it. If Member Paulton wants to, offer an amendment that just takes out that bracket, I think it makes sense to address her concern. I will just raise, I remember the second question regarding just kind of blocking out addresses, even for the public filers. And the only thing I'll mention on that is, when people are looking at these financial disclosure statements to try and find out if there's a conflict of interest, they'll look at where the person owns property and if they're making a decision that directly affects property like that. And if they can't see where the property is, that could potentially, undermine kind of the ability of the public to kind of look at these things and hold people accountable. That's just one thing that I'll mention regarding redacting addresses.
Okay, but redacting this, like the house address, you can leave in the city and the zip code like that, because then that doesn't give someone the exact place that you live. And so if the concern is what kind of influence is your residence or property that you may own have in your decision making, then the city that you live in should be sufficient, right?
I mean, for example, if it has Wailuku in there and, there's a vote before the Planning Commission on a specific development, or for example, it's a property that's TVR, just saying that it's in Kaanapali won't necessarily say that. But you're probably right that leaving off the address or the apartment number would potentially address those concerns, because you'd still be able to identify, the important stuff. And that was just something that I mentioned. That's kind of a policy concern. That's not really a legal concern, I don't think.
So my last follow-up question to that is, does the county then have the discretion to redact the house address or apartment address? Or is that something that we would have to provide the authority in this bill? Whoever.
Can I have a point of information for Member Rollins Fernandez?
Oh, yes, please.
I just wanted to clarify, when what you're asking, we're not redacting it from the Board of Ethics review. We're just redacting it from public view, correct? Is that what you meant?
Yes.
Okay.
Because I agree with you about leaving in subsection D. And so if it's all going to be, continue to be uploaded to the document center on the county's website that shows everyone's financial disclosures from as long as they've been running for office, then they can just go in there and redact the house address, right?
Yeah.
So in that subsection D, does the county have that authority, or did we have to give that authority to do that?
So the only thing that I would mention regarding that is, both the Board of Ethics administrative rules, as well as if you look at this section B2, those have what's required to be included in a financial disclosure statement. And in here, B2, it says the tax map, key, or street address of all real property that is currently owned. So an idea that might make that work is if you added a provision to section D, since that's where we're making clear that financial public disclosure statements are public records available for inspection. You could add, a clause in there, maybe stating that except house numbers may be redacted or something like that. Because I think that would make it clear that that's an exception to the public inspection. And then that way, because would be legislative, it also really wouldn't require a rule amendment because the Maui County Code would supersede the administrative rules of the board.
Mahalo for that. Appreciate that. Mahalo, Chair.
Good discussion, thank you. Members, do you guys have any more discussion?
Chair, if I could just add a couple of things.
Please.
Thank you. So back when the election season started, or maybe about 6 months in advance of that, everyone in my office that works in elections, which is every employee, we had all of our home addresses taken off of the real property tax site. So if you happen to know where any of us lived at that time and you were to try to search us now, you will not find us there. And that's part of this security measure. We also, through the FBI and Homeland Security, were able to apply for a program called Delete Me, which basically scrubs all public sites and removes any identifiable information for us, such as our home addresses and phone numbers and so forth. So in terms of the importance of us being able to keep that confidential, although we haven't had direct threats at our homes, this is a nationwide action that goes on for all election workers, and that's why we're asking for support for that today.
Thank you. Member Rollins Fernandez.
Mahalo, Chair. For Ms. Ludi, which specific provision are you referencing in the bill? Sorry.
It's 2.56060 and in parentheses 3. It's the county clerk and deputy county clerk, that section.
Got it. Mahalo.
Thank you.
And I'm so sorry that this has become such scary times to all of our election workers.
Yeah, exactly right. Any other questions? Member Paulton?
Oh, I just wanted to clarify. So if section 3 or 2.56.060A3 were to say county clerk and deputy county clerk for purposes of election, official security, the county clerk and deputy county clerk must file a public financial disclosure statement with all addresses redacted from the public disclosure. That's not acceptable.
Member Paulton, you're saying that when we submit it, it would not have that information in it?
Well, like you submit the information to the Board of Ethics, and then when it's posted publicly, all the addresses are redacted.
I think the biggest concern for us on that is human error and whether or not that actually is secure. But we also have we have to put our phone numbers on it too. And so typically I'll put in my cell phone, although lots of people have that, but that's part of what also goes on there. So
Like all personal contact information be redacted, but the rest of it be public, no?
yes, we just don't want people to be able to find us.
Is other jurisdictions have the clerk and deputy clerk financial disclosure confidential?
I'm not sure if they file financial disclosures in the manner that we do because it's specific to jurisdictions, but what I can tell you that all of us work with the FBI, CISA, and the Fusion Center, which is a branch of the FBI, to participate in Delete Me so that all of this is scrubbed for everyone, excuse me, that works in elections. And we've heard horror stories, right? When we meet, we do have security meetings that are run by the State Office of Elections where they bring in retired clerks and also the FBI and other members of the federal law enforcement branch to talk about how there have been people that have shown up and taken captives in the homes of clerks or followed them, made death threats and so forth. It hasn't been here in our community, but this is a nationwide concern.
Okay, thank you.
Yikes. Members, any other questions? No? Okay. Seeing none, I would like to entertain a motion to recommend passage on first reading of Bill 3, 2024, including any non-substantive revisions. Thank you. I have a motion made by Member Cook, second by Chair Lee. Any further discussion?
Chair,
Please.
I think that this is, we're fortunate on our island home that we have not had this type of problem, but I totally am supportive, and I think that it's prudent to indemnify and protect the people who work in the office as much as possible. Thank you.
Thank you. Member Paulton?
I move to amend, this bill is not numbered on pages, but I guess in the
Would you mind if I make my amendment first and then we
Substitution.
can work on the CD1 version and then you can make your amendment on the CD1 version so we can keep it consistent?
So moved.
Thank you. Okay. I would like to entertain a motion to amend Bill 3, 2024 by substituting Bill 3 with the CD1 version attached to the May 21st, 2024 correspondence from Corporation Counsel posted on today's agenda. I have a motion made by Member Paulton.
Second.
And a second by Member Kama. This version includes boards and commissions established on or after July 1st, 2024 under the financial disclosure filing requirements and is approved to form in legality by the Department of Corporation Counsel. Member Paulton, did you have any other additional amendments you'd like to make?
Yes, please. I'd like to move to amend 2.56.060, the bracketed portion of letter D and to move it, that first bracket, to the sentence that says, all confidential financial disclosure statements shall be filed with the Board of Ethics and shall be confidential.
Okay. I have a motion made by Member Paulton and a second by both Member Kama and Member Rollins Fernandez. Okay?
And I just wanted to verify with the county clerk, there's no federal database of elected officials getting harassed, right, at their houses?
I know of some cases of it, but it's not as common as it is for election officials. And one other thing that I would point out that seems to be commonplace when we've met with the FBI is that it's typically targeted towards women, because the majority of clerks or county clerks across the country are females. So
in
but I
that
don't know about you
case,
guys. Yeah.
maybe add in before that first bracket that personal contact information must be redacted for that part D. So it would read filing requirements. Oh, go ahead.
We're going to say that's a friendly amendment. Member Paulton, would you like to work on this as a friendly amendment?
Yes, please.
Super friendly, okay. Did you have anything else you wanted to add? And then I'm going to call a Member Rollins Fernandez.
Just that it would say the filing requirements, all public financial disclosure statements shall be filed with the county clerk and shall be public records available for inspection, and that personal contact information for dwelling and telephone must be redacted. Like residents, not extra properties or anything.
Member Rollins Fernandez, you had something to add?
Yeah. So I wrote something for consideration as well. Similar. It would just be after the and, except for the filer's residential address. So I put the home address, but I can add the phone too.
Friendly amendment.
And then, yeah.
Okay, will you do me a favor, a favor then, Member Rollins Fernandez? Would you, I don't see it on anything. Would you read out what D would read then with your amendments?
Yep.
Thank you.
Filing requirements, period. All public financial disclosure statements shall be filed with the county clerk and, except for the filer's residential address and phone number, shall be public records available for inspection.
Okay.
I accept that friendly amendment.
Okay, sounds good. Shall we vote?
Can we still have discussion?
Yes, please.
My discussion is to ask the county clerk your opinion on this amendment.
If I could, I believe that that would mean that that would apply to all public financial disclosure statements, that the home address, the residential address, and personal phone number would be not public, so potentially redacted.
Is this something that you are in favor of? I thought I heard you say earlier that the thing with redaction is the possibility of human error. You still feel the same, and therefore not in favor of this amendment?
This amendment, yes, if this amendment applies to the clerk and deputy clerk positions, we would not be in favor of this amendment because we believe that the financial disclosure statements contain a significant quantity of information that somebody who knows a little bit of their way around the internet could put it together and figure out, basically, it's not only where we live that we're in fear of somebody coming to our homes with a gun or something like that, but causing us financial harm by messing around with our accounts, hacking us, doing different things. So there's a lot of information in financial disclosure statements that a savvy person could use to attack you. Maybe not physically. It could be, like I said, online. So we're really hoping that you keep in number 3, which would make our financial disclosure statements confidential.
Okay. Thank you.
Thanks.
For the record, this current amendment only addresses Section D and does not touch item number 3. So it's for, I think, the rest of us who have to file disclosures that our personal address and contact information is not made public, but Section 3 relating to the county clerk and deputy county clerk is still in there as a confidential financial disclosure. To be clear, yes? Yeah.
That's correct.
Yeah, I want to make that clear. So that is for all public financial disclosure statements shall be filed with personal contact information redacted with the county clerk. So that's all of ours. Our personal information is not made public, but the county clerk and deputy county clerk, their number 3 is still in there, and their financial disclosure statement is confidential and is not public like the rest of everybody else's.
Correct.
So is that okay?
Thank you. Yes.
I would prefer to keep our county clerks as safe as we possibly can. And that includes everybody who works in their office as well. And like Member Rollins Fernandez said, I'm so sorry we're even living in these times. Members, do we have any other amendments? I just got word with new rules that we can vote on this amendment with the CD1, and we can do it at one time. One time, which is so exciting. We still have to vote twice, but anyways. Okay, so all those in favors for the amendments, please raise your hand and say aye.
Chair, that's 9 ayes, 0 noes. Motion carries.
Thank you. Members, any discussion before we vote on the main motion as amended? Okay, well in that case, Member Rollins Fernandez.
Really quick,
Yes.
I did send my amendment to staff. And so I just wanted to include non-substantive revisions to that amendment so they can clean it up and make it nice for the committee report.
Thank you. Got it? Thank you. Okay, well, if there's no further discussion, all those in favor, please raise your hand and say aye for motion as amended. Aye.
Chair, that's 9 ayes, 0 noes. Motion carries.
Thank you very much. Thank you so much. See you guys later. Okay, we have before us Resolution 25-52, which would approve and authorize an increase in compensation for the employment of Special Counsel ESNA Incorporated, a law corporation, for the representation of Scott Martin in this case by $150,000 for a total compensation not to exceed $200,000. At this time, I'm going to ask for opening comments by Deputy Corporation Counsel Glenn Pasquale. Mr. Pasquale?
Good afternoon, Chair Hodgins, Vice Chair Paulton, and members of the Great Committee. As you know, the Council previously authorized the retention of ESNA Incorporated as Special Counsel to represent Captain Scott Martin in the lawsuit filed by Chelsea Evans, the mother and personal representative of the estate of Trey Evans Dumoran. I believe Anna Elento-Sneed, the lead attorney from ESNA Incorporated, is present via video conference. I'm here today requesting authorization to raise the compensation limit for the employment of Special Counsel ESNA Incorporated from $50,000 to $200,000. This increase is requested in anticipation of the increased time and expenses that will be incurred in litigating and defending Scott Martin to trial. Currently, there is no trial date set, as I understand it. However, a scheduling conference is scheduled on May 14, 2025, at which time a trial date will be set. Anticipated time and expenses would be for things such as conducting and reviewing discovery, reviewing documents, depositions, expert witnesses, motions, other pleadings, and attending court hearings. I don't anticipate having to go into executive session, but however, if the questions you ask infringes upon something that may require executive session, I reserve the right to request executive session. Thank you.
Thank you very much. We have Fire Chief Ventura on the line and will be available during discussion. He does not have any opening comments. Before we get into discussion, though, can we please ask for any testifiers on this resolution 25-52?
Yes, Chair. There is currently no one who has signed up to testify, so I can do a last call.
Please.
If somebody would like to testify in the chamber, please let staff know, or on Microsoft Teams, please raise your hand. This is final call. 3, 2, 1. Chair, it appears that nobody wishes to testify.
Thank you, Member Singh. There are no individuals wishing to testify. Without objection, I would now close oral testimony for this item. Thank you. And as a reminder, written testimony will continue to be accepted. At this time, we're going to do another 3-minute questioning period with a follow-up round if necessary. Members, if we do need it to go into executive session, we can do that as well. But I'm not going to be going down any rows, so if you have any questions, please raise your hand. Member Paulton.
Thank you, Chair. My question is, I'm not a lawyer. Sometimes they say that whoever is the winner has to pay the other person's legal fees. Is this that kind of case?
Thank you for your question, Vice Chair Paulton. In most civil cases, potentially that could be the case. Certain conditions have to be met. But this case is still kind of too early in the process to determine whether or not the attorney fees of the other party or of one party or the other will be recoverable by the other party.
So the answer is possibly, but we don't know yet.
Yes.
Okay. Just breaking it down to my non-lawyer level.
That was a good question. Not a problem.
Anybody else have any questions? Member Kama?
Thank you, Chair. So, Mr. Pascual, so you're asking for an increase of 150,000 more than what we gave you earlier, which was 50,000. Is that correct?
Yes.
So, what do you anticipate this whole case costing at the end of the road?
It's hard to say. The amount that we asked for was based on this kind of an estimated amount of time that would typically be put into these types of cases. Every case is different. I think, it'll be hard to say what the amount will be. It all depends on, how many motions are filed, how many depositions are taken, and so forth.
At some point in time, you've got to cut your losses, right? I just want to figure out where are we at in that. Are you saying this is too soon in the development of this lawsuit to determine that?
I think the amount that we're asking for, fits within the budget of what would be anticipated to occur all the way up to the trial. If the case does go to trial for Scott Martin, then depending at that point, we may have to come back and ask for more. But I don't have a crystal ball. I can't really tell how litigious this case will be. But the amount that we're asking for is actually kind of based on looking at what kind of work would be done up to the point of trial, as I understand it.
Okay. Thank you so much. Thank you, Chair.
Thank you, Member Kama. Member Paulton?
Thank you, Chair. I just wanted to clarify, we don't decide whether or not we're gonna provide, counsel for the person. We're just deciding if we're gonna pay, because the Fire and Public Safety Commission decided that the captain is entitled to legal representation. So if we don't fund it, then we're in violation of what they chose to do. We don't, is this just, I don't know the right word, but it's something like, is it just a formality? Because they already determined that we need to the county needs to represent him acting in his official capacity, right?
Just to clarify, Vice Chair Paulton, it wasn't the Fire Commission that requires the county to provide representation for Mr. Martin. It's actually state law.
Oh, okay. Wrong entity. But
yeah.
It's required. So, I mean, is this like you coming to us for a vote? If we vote no, then we're in violation of state law.
Let me just read to you what the statute provides. And this is Hawaii Revised Statutes 46-35, duty to defend. Whenever any firefighter is sued in any civil case for acts done in performance of the firefighter's duty as a firefighter, the firefighter shall be represented and defended. In a civil case, the firefighter is to be defended by the corporation counsel or county attorney. Now, again, this is just a duty to defend. It's not a duty to indemnify. So we're not, if there is a judgment against Mr. Martin, then the county council, the county isn't paying for that. But we do have to provide counsel representation for Mr. Martin.
And the reason we're going with a outside, not the deputy corp counsel, is because we're conflicted.
That is correct.
So, I mean, I feel like we don't necessarily have a choice. We got to comply with state law.
Yeah, as far as providing representation, I guess the choice that's here today before you is the amount.
I mean, I understand the intent of the law, and it's not saying you should provide shitty representation or junk representation. So, I mean, I'm inferring the intent is to provide good representation.
Yeah, I think that's goes without saying, that you want to get competent, adequate representation.
Thank you.
Ms. Minitodani?
Vice Chair, I think it is what Mr. Pasquale said. It's two separate issues. One is for HRS 46-35, and then the other issue would be the cost. And I think it's just a matter of trying to keep it reasonable and appropriate the amount of money to.
Add. Do you have anything else to add?
No, I don't have anything else to add.
Okay, thank you. Members, do we have any other questions? Member Kama.
Who decides what law firm that we or you all are going to hire to represent, our county employees when we have to defend them?
Okay. Yeah, I think at this point I may have to ask for, because the question may kind of deal with an issue pertaining to the powers, duties, privileges, immunities, and liabilities of the county. I would have to request executive, that we convene an executive meeting to discuss that.
Let me think how important the answers would be to do that. Well, I was going with the thought of that ESNA, who is the attorneys, right? We gave them $50,000, and now they want 3 times as much again, because they anticipate. I mean, I think good. I think good. That's what I want to know.
Do you have a pre-approved list of special counsel that you pull on when you need to defend on X and they specialize on X?
Yeah, again, I think I would have to ask that we go into executive meeting if we're going to discuss the process.
Members, do you guys have any other questions that we need asked in open session before we reconvene in executive session to answer Member Kama's question? Member Paulton?
I won't be voting to go into executive session because I trust Mr. Pasquale.
I would prefer not to, but especially if we only have one question. But if anybody else has any other questions that we might need answered, I'm happy to do so. I'm happy to accommodate executive session if necessary for Member Kama, but do you want to have a separate discussion with Corporation Counsel without us?
I could.
Okay.
So that everybody doesn't have to go into exec session.
Is that okay, Mr. Pascal?
Sure, that's.
Is that okay with us?
That's fine with me.
Okay, thank you.
Yep.
Thank you.
Members, any other questions? Nope. Okay. Seeing none, I would like to entertain a motion to recommend adoption of Resolution 25-52, and I didn't read it earlier, so I'll do so now. Authorizing additional compensation for Special Counsel ESNA Incorporated, a law corporation in Chelsea Evans individually, and as the personal representative of the estate of Tre Pu'uvai La'a Hia Olopaka Amele Huanani Evans Dumoran deceased v. Scott Martin Civil 2 CCV -24-000034, including any non-substantive revisions. I have a motion made by Member Cook, second by Member Sugimura. Any further discussion? Seeing none, all those in favor, please raise your hand and say aye. Aye.
Chair, that's 9 ayes, 0 noes, motion carries.
Thank you very much. This item will move on to full council for its consideration. Do you guys want a break? We're on our last item, okay?
Only if you need one chair.
I'm okay for now anyway, but if anybody else needs one, this one might require executive session, so you want to take a 10-minute break? Sure. We will take a 10-minute break. It is 2:33 and we will return at 2:43. welcome back. Great committee. It is 2:48, and let's please reconvene. We have before us Resolution 25-75, authorizing additional compensation for Special Counsel Kobayashi Shigita and Gouda? No, that's not Jaji's, Gouda. LLP in Christopher Salem v. County of Maui et al. Civil 2 CCV-21-000048, which would authorize an increase in compensation for the employment of special counsel for the representation of the County of Maui, Richard T. Bisson Jr. in his official capacity, and Kate Blystone in her official capacity by $475,000 for a total compensation not to exceed $925,000. And at this time, I'm going to ask for opening comments by Deputy Corporation Counsel John Gores before we go into testimony. Mr. Gores.
Thank you, Madam Chair, members of the council. This is my third time coming back on this matter. I think the council is well aware of the underlying matter. We're here requesting the additional compensation for special counsel to continue and proceed through trial, which trial now is set. This is the second trial that was set for June, and special counsel Mr. Shikuma is available today here by video. I'm happy to entertain any questions, but I anticipate most of what we will be discussing will be an executive session.
Mr. Shikuma, do you have any opening comments?
No, Madam Chair, I would reserve any comments for executive session.
Okay. At this time, staff, could we please see if we have any testifiers?
Yes, Chair. There is currently no one who has signed up to testify. Would you like me to do a last call?
Please.
If somebody would like to testify in the chamber, please let staff know. Or on Microsoft Teams, please raise your hand. This is final call. 3, 2, 1. Chair, it appears that nobody wishes to testify.
Thank you, members. Seeing there are no individuals wishing to testify without objection, I will now close oral testimony for this item.
No objections.
Thank you very much. As a reminder, written testimony will continue to be accepted. At this time, I am going to ask you folks to raise your hand. We will again have a 3-minute questioning period for any questions that can be asked during open session before we move on to executive session. So members, if you have any questions, please raise your hand now. No questions? Okay. Okay, seeing we have no questions for open session, I would now entertain a motion to convene an executive meeting in accordance with section 92-5A4 Hawaii Revised Statutes to consult with legal counsel on questions and issues pertaining to the powers, duties, privileges, immunities, and liabilities of the county, the council, and the committee, and section 92-5A8 Hawaii Revised Statute to deliberate or make a decision upon a matter that requires the consideration of information that must be kept confidential pursuant to a state or federal law or court order. Can I have a motion? I have a motion made by member Sugimura, second by Chair Lee, to enter into executive session for Resolution 25-75. Any discussion? Seeing none. All those in favor, please raise your hand and say aye. Aye.
Chair, that's 9 ayes, 0 noes. Motion carries.
Thank you. For the record, all following personnel will be attending this executive session meeting. All council members in attendance, including myself, Committee Chair Nohelani U'uhajens, Committee Vice Chair Tamara Paulton, Councilmember Tom Cook, Councilmember Gabe Johnson, Councilmember Tasha Kama, Council Chair Alice Lee, Councilmember Kiani Rollins Fernandez, Councilmember Shane Senensi, and Councilmember Yukile Sugimura. Office of Council Services staff that will be attending is Peter Hanano, Legislative Attorney, Rochelle Kawasaki, Deputy Director of Council Services. Is she here? Okay, sorry, I didn't see you over there in the corner. Maria Leon, Committee Secretary. From Corporation Counsel, who would be attending this meeting will be Cody Minutodani, Deputy Corporation Counsel, yes? Okay. John Gores, Deputy Corporation Counsel, and Mr. Shikuma, Special Counsel of Kobayashi, Shigita, and Goda LLP. Anybody else? Did I miss? Okay. At this time, I would like to call for a 5-minute recess to 3:58 p.m. and we will convene an executive meeting. Yes. I'm sorry, 3:58. 2:50. Oh, we're earlier than I thought. Okay. I was giving us less time. This is new for me. This is really early for us. Okay, thank you so much for catching that. Will this great committee please go into recess for executive session? Will the Government Relations, Ethics, and Transparency Committee meeting reconvene? It is 4:14 p.m. Members, we have just completed our executive meeting on Resolution 25-75. And at this time, I'm going to ask Mr. Hanano to provide a summary in accordance with Act 29, 2023.
Thank you, Chair. Your great committee met in executive session where there's a discussion regarding special counsel's assessment and mental impressions of the case, which also included a discussion of legal strategies, settlement efforts, as well as the rights and liabilities of the county. Thank you, Chair.
Thank you. Is there any further discussion before we go to my recommendation? Seeing none online at this time, then, I would like to entertain a motion to recommend the adoption of Resolution 25-75, including any non-substantive revisions.
So moved. Second.
Thank you. I have a motion made by Member Sugimura, second by Member Kama. Any further discussion? All those in favor, please raise your hand and say aye.
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 Chair, that's 9 ayes, 0 noes. Motion carries.
Thank you. This item will move on to full council for its consideration. At this time, this concludes the Government Relations, Ethics, and Transparency Committee meeting. Thank you very much, members. It is 4:15 p.m. and this meeting is adjourned.
Very good, very good.